Good morrow to you, ladies and gentlemen. I desire the art doing most wondrous, and thy learning is valorous. Well, that is how Shakespeare would have said. I hope you're doing great and your studies are good. I do hope you're revising the concepts and knowledge as a routine now, and also finding the parallel learning in these videos almost randomized, not just interesting but also enriching. Continuing the flavor of the previous video, in this one I've got some key personalities of the theatre world, from the world, depicting the different schools and techniques and some big names of playwrights. All right, so let us take 10 more questions here and continue to learn about the system of governance of India. Please do keep the copy of Constitution of India handy for reference. I will direct you where needed. And for best learning, as always, I recommend you pause the video after each question is displayed and mark your answer, and only then proceed to listen. This will help you, I'm sure. Take it as a mini test, as I say. You may also join the Telegram channel mentioned in the description of this video for more quizzes and other relevant information. Okay, so here goes the first question of this explanation video. Which of the following are a consumer right recognized under the provisions of law in India? I'm sure if you have been focusing on your current affairs over the last 1 year, the Consumer Protection Act, okay, the Consumer Protection Act 2019 has been enacted in August 2019, and it has repealed the earlier Act of 1986. Okay, so it seems important for our exam this year especially. Okay, 6 consumer rights are provided in the Act. So I would recommend you just download it and just go, I think the very second page, it says consumer right means, and there are 6 rights. Essentially, it talks about the right to be protected against, hazardous goods and services, right? Then also it talks about right to be informed about the quality, quantity and things like that. Then a right to be assured access to variety of goods and products and competitive prices. That's very interesting. Then it talks about right to be heard and regarding consumer redressals. Then right to seek redressal from unfair trade practices and restrictive practices, and right to consumer awareness as well. So the 6 rights in the Act you should know. I just picked 3, and actually I wanted you to learn, so it's not really a test here. So all of these are actually a consumer right provided under the law in India. Please also prepare a short note on the changes that the new Act has brought. We will have a question in the upcoming videos on this aspect as well. So moving on to the next question, and that is the value of the currency note in India is not printed on the note in which of the following 8th schedule languages? Now, as you know, there are 22 languages in total mentioned in the 8th schedule, and out of them, actually, 6 of them are not on the note. And these 6, it's not very difficult. You'll see that the original constitution had 14. And 8 more have been added after that. So out of these 8, 6 of them are the same. So if you see, the last edition was of your Bodo, Dogri, Maithili and Santhali, which was added by the 92nd Constitutional Amendment Act of 2004. Then before that you had Manipuri along with Konkani and Nepali, which was by the 71st Amendment of 1992, and the first one was, we know, Sindhi was added by the 21st Amendment of 1967. So anyway, so you will see that the 6 languages in which it's not there is all the 4 in the last one, right? And before that, Manipuri and Sindhi. Okay, so the answer should not be that difficult. That Nepali is there on the currency. Konkani is also there in the currency. Essentially, it is the Manipuri and Maithili 2 and 3. Anyway, not something extraordinary, largely factual, but you should have a sense of it. I hope you know how many languages, in how many languages the value of the currency is printed on the currency note. If not, I am the last person who will tell you. Take out a currency note and see. Okay, next question we have. Oh, by the way, this is not a great performance. Anyway, next question is, which of the following statutes provide for preventive detention in India? This is again something which is not a test. It's just to tell you that all of them are actually have provisions of preventive detention. I'm sure you understand the idea of preventive detention. See, in the regular criminal justice system, the law works to limit arrest and custody. Okay, you know the rights which are provided under Article 22 of the Constitution of India. Okay, so for example, the police needs credible basis to arrest, and pre-trial detention is not extended beyond 24 hours without some investigative purpose, right? And it is also subject to periodical review, where the court will keep checking is the remand should be extended or not. The law also carries safeguards for those arrested, like right to be informed of the ground as soon as possible, and to be presented before a magistrate within 24 hours, and to be defended by a lawyer of your choice, things like that. However, in case of preventive detention situations, none of this holds true. None of these rights are there. Preventive detention laws allow arrest if an executive officer is satisfied that a person is dangerous to society, right? And different laws are there for assessing different dangers. It is absolutely acceptable for no grounds to be given even up to 5 days, and in some cases up to 15 days as well after arrest. Detainees are not produced before a judge at any point, and there is no review of the need for detention as well. And worst of all, perhaps, detainees do not have the right to a lawyer. I'm sure you are aware, all these exceptions which are there under Article 22 of the Constitution. So anyway, more of a learning point that all of them have a preventive detention component in our country. So let's move on to the next question, and that is the Official Secrets Act. It has been in the news, and it has been a lot in the news. Which of the following statements are correct regarding this act? Okay, the first statement says that it applies only to the servants of the government. No, that's wrong. Actually, this is also a question which I thought you should know more from a learning point of view. So, second, third and fourth are correct. You just learn it, read it yourself. Now, for the first point, you should know that it is applicable to, all the citizens of India, even those who are outside India, okay, and also to the corporates. In fact, even the person in charge of the corporation can be held guilty, right? And another important thing you should know that even if the action was unintentional, the intention need not be proved. A typical criminal justice system you would have understood or learned and watched also through the movies that we have, that the action is there, but even the intention becomes important to be proved. Otherwise, there is a lesser, punishment in cases. But here, it's not at all important. Okay, unintentional presence in, let's say, prohibited territories, that itself is sufficient to charge you. Anyway, so as I said, this is more for your learning and knowledge, because this is roaming around us. Please read the provisions that are written here. And the next question is, which of the following statements are correct with reference to the PMO? Okay, it has the status of a department under the Government of India, allocation of business rules in the AOBR. Yes, it is considered as a department, and essentially what is the purpose of PMO is to assist the Prime Minister in the discharge of his duties. So as you know that the Prime Minister of India or in general a Prime Minister in a parliamentary system is considered a residual legatee of the government. That means all the leftover responsibilities that is not specially allotted to any other individual department, they all fall in the plate of the Prime Minister, and that's where comes the role of the Prime Minister's office. Of course, it is headed by the Principal Secretary to the Prime Minister, and so all three are correct. Should not have been that difficult. Yeah, okay. So let's move on to the next question, and that is, which of the following statements is or are correct? The notification for general election to the Lok Sabha and State Assembly is issued on the advice of Election Commission. I have asked you earlier also to read at least section 14 and ideally even section 15, but section 14 is for President, section 15 is for the Governor of the state, that they will issue the sections of RPA 1951. So they will issue the notification of election on the advice of Election Commission. So this first statement is correct, and it says the notification for general election to Lok Sabha and State Assemblies is issued by the President of India. Now think about it. Why would the state assembly election would notification will be issued by the president? So that's where it was just a small test of your presence and presence of mind and ability to read properly, that only the Lok Sabha notification is by the president, state assembly notification is by the governor of the state. Otherwise this statement as such is okay. So second statement is wrong because of this reason. And as you can see, this is not that difficult a question, but still less than half of you are getting it right. Even though we have already reached 306th question, it's not 6th question of the series. Well, I hope once I resume the quizzes after completing 400 questions here, I will see better performance. So let's hope so and go to the next question. Arrange the following offices in the decreasing order in the order of precedence as established by the President of India. So a lot of information I've already given you here, that the President of India establishes the order of precedence, and it is maintained by the Ministry of Home Affairs. See, what is an order of precedence? It is just the ceremonial protocol and nothing more. There is no legal standing of this precedence order. Okay, so it is just issued by the President's Secretariat and maintained by the Ministry of Home Affairs. So if you see most of the top 5, 10, if you see, they are very logical, that at the top of the order of president will be the order of precedence will be the president, followed by the vice president, and then followed by the prime minister of India, then followed by the governor of the state within the state. So if they are outside the state, their hierarchy is obviously lesser. Then you have the ex-presidents of India. You have after that the speaker, as well as the Chief Justice of India at the same place. Then you have the cabinet rank ministers or the chief ministers. They have equal status. Even ex-prime ministers are here. Leader of opposition, has the same rank and status as cabinet ministers. After that, you have the Bharat Ratna holders, and followed by the ambassadors, and then the judges of the Supreme Court. So if you look at that, your correct order here should be at the top in these options will be the Speaker of Lok Sabha, and then you will have the cabinet ministers, followed by the ambassadors, high commissioners, and then the judges. So it should be like 1, 2, 4 and 3. Yeah. So that should be anyway. I mean, as long as you get the point answers, you can arrange. Don't just see that I put a tick here. Just get the point, and that should give you the answer. All right. So let's move on to the next question. In case you could not see the previous one, that's Grotowski. Which of the following is or are a compulsory provision under the Constitution's 74th Amendment Act? I'm sure you can relate easily that this deals with the urban local bodies or simply the municipalities in India. 73rd Amendment was what dealt with the panchayats, that is part 9A, and urban municipalities, that is part 9A is urban local bodies, and part 9 is your panchayats. So anyway, rotation of seats reserved for women. Well, it's not really necessary to read these articles, but at least you should have read it for panchayats. Anyway, for the urban local bodies, the relevant article is Article 243T, which is very similar to the Article 243D for the panchayats. So if you have read panchayat provisions also, that is sufficient. You can read again. You'll see that it is not a compulsory provision. It's up to the state, and they may by law provide for these reservations. So one is actually not the correct option here. Constitution of a State Finance Commission to review financial position of the municipalities. If you read the provision here also, and that is 243Y, which is very much like 243I of the panchayat provisions. So 243I constitutes the State Finance Commission, and that was provided by the 73rd Amendment. Okay, and the same State Finance Commission is referred under the 74th Amendment. Under this Article 243, it says that the State Finance Commission that was appointed under 243I will do this work for the municipalities as well. So actually the Constitution part is not there in 74th, it is actually from the 73rd under 243I, 73rd Amendment. Anyway, constitution of a DPC at the district level, I'm sure you know. the two important committees that the 74th Amendment appoints. One is your DPC and the other one is the Metropolitan Planning Committee, Committee for Metropolitan Planning. See, District Planning Committee, even if it involves rural areas like areas under panchayats, their planning is done by this body only, which was created by 74th Amendment. There is no planning kind of a provision like this kind of a district level planning in the 73rd Amendment Act. All this planning etc. is actually from the 74th Amendment Act, that is your 243 ZD and ZE. Anyway, so third is actually the only correct statement here for us. And lo and behold, see, the performance should have been better because, yeah, I mean, of course, it's slightly tricky because it talks about constitution only, it talks about specific committees. As I say, keep learning, let's improve ourselves. Okay, so the next question we have is which is correct regarding the Advocate General of a state. This is also a question where I felt a lot of people got confused. See, Article 165 talks about the Advocate General, and it says that Advocate General for the state can be a person who's qualified to be appointed as a judge of the High Court. Now, qualifications for the judge of High Court, they are provided under Article 217 Clause 2. Which essentially talks about three things: that the judge of the High Court should be a citizen of India, should have held a judicial office for 10 years in the territory of India, or should have been an advocate of one or more high courts for 10 years. So these are the three possible combinations that is possible. Of course, the citizenship has to be there. So that's all it is required to be fulfilled. There is no qualification as to age. Okay, and age is more of a condition of service that they will retire at the age of 62, the judges. Supreme Court has also held that the provisions regarding age cannot apply to the Advocate General because the provision does not occur in Article 217 Clause 2. Essentially, what one must understand is that all the provisions relating to High Court judge cannot be made applicable to the Advocate General. Say for one more example, the removal process, it's not going to be the same. Okay, so that is why this second provision is actually not valid, because while for judges it's a retirement age, that is not a qualification as such, and hence Advocate General can actually be older than 62 also, and qualified to be appointed as a judge of High Court. First statement, that is obviously correct. So only the first statement is correct for us, and we need to improve. But I think there was a nuanced learning that you needed to understand here, that qualification doesn't mean conditions of service. Okay, it's not exactly the same thing. Alright, so we go to the last question of this video. Which of the following situations would require a votes of credit to be passed by the House of People? Let us see. To meet the situation when the money has been spent more than the amount granted in the budget. Well, this is actually what is called the excess grant. Okay, and that's kind of an obvious name also, where the money has already been spent more than what was granted. To meet expenditure as advance for a part of financial year. Well, this is also not the answer to the question because this is what we call, I'm sure you can recall, this is what is called the vote on account. A couple of questions have come on this also earlier in our videos. Vote on account. Nowadays, we don't have vote on account because the budget session has been preponed. So we have enough time to pass this. We don't have to wait till appropriation bill is enacted. Then to meet the expenditure even without any corresponding source of revenue for the government. Well, expenditure is not proposed anyway with a corresponding revenue source. Yes, at the gross level it has to be matched. And the deficit, if any, has to come from the borrowings. But it doesn't mean that every expenditure has to be matched with the corresponding source of revenue, one-to-one matching. No, it's just that the total revenue, total expenditure should be there. That's all. So that's a meaningless statement as such. And fourth one, by now we know that should be the answer. It says to meet unexpected demand where the magnitude of demand cannot be stated with details. That is exactly what the Constitution specifies, and this is your votes of credit, where we don't know exactly how much magnitude of the demand is there. In this case, some people may get confused with what is called a token grant. See, token grant is very different. Token grant is essentially where you just make a token amount, let's say rupee 1. And through reappropriation means from other grants you can transfer the money here in this particular service that we want, and that is possible. Then you go for a token grant. So this is not a situation of token grant the way it is given. It is just that we don't know the entire magnitude, so we'll go for votes of credit. Okay, so and that's the last question. And since I began this video by mentioning Shakespeare, perhaps the greatest of playwrights of all times, I will leave you with some Shakespeare, some popular dialogues from his works, and you will see a lot of them are prevalent in regular usage of English language even today. You may pause to have some glimpse into his world here. And that's all for this video. I hope you found it useful. You may see the next video in the playlist to continue with this series and 10 more questions. Thank you very much.